Far Road.
Yeah, that's way down. That's damn near to the county. Plate. You ever been down here in this building your tax dollars are paying for? The new headquarters? Man, just call me Quinn, man. That sir shit makes me nervous. I'm just Quinn. Nobody call me...
Protocol,
I know, but don't nobody call... It makes me feel funny. I know. But you can just call me Quinn. Everybody, call me Quinn. Don't call me Detective Quinn. None of that shit. Just Quinn. I mean, this building is really nice, though. I mean, I'm surprised they didn't have an open house, for the citizens. It's the best shit they ever did for us. Got a fully equipped gym in that motherfucker with goddamn saunas and showers and shit, lockers, which ain't good for police because they can slick come back by here on the way home, take a shower, you know what I'm saying? That ain't always a good thing. Oh, man, y'all fucking blocking and shit. Come on now. Wanna be motherfuckers, man. Do. Damn, they give out 2 sandwiches and cookies. What's in all this bologna? Damn, they still doing bologna? What about the Muslims? What do they eat? You don't eat pork. What do you eat? How they swing that shit, I wonder. All right, brother. Take your time. Oh, watch yourself. Let me know if I touch your injury. I know you got a few injuries. Okay, all right. I also I got to make note of all your injuries. I want you to tell. I may have to take pictures of them, too. Did they do that first day at Grady, or they didn't take pictures of them? I got to get a picture. All right, I'll take some more pictures of them. Because I want to be able to show, if you're saying what happened to you, I need to know and have a documentation of it.
It ain't so much where it's at now. You know how your muscle go out?
Yeah. I got you. Take your time. Ain't no rush. P-Dog.
You just put it up to offset it a little bit from.
Matter of fact, I'm going to take that thing. Which one is the problem ankle?
It's his left.
All right, that's the right.
Right.
All right, I'm going to take that one off when we get upstairs.
Every time I X-ray.
Yeah, I'm going to take that one off and just take off your handcuffs and let you eat your food while I go do the shit I need to do. Right here. Hey, what's up, brother?
All right.
Like a left right here.
Back, I relied on my training and past experiences to handle it.
Were you angry at Mr. Sullivan?
No, not at all.
Were you doing the job that you were trained to do?
I was.
So immediately after this event took place, the days that followed, what happened as far as your job is concerned?
So immediately,
Your Honor, I'm with relevance items.
You want to come up here for a second?
I don't think I do either.
Sir, after this incident took place, were you required, pardon me, were you requested to make a statement,
yes, I was.
a written statement?
Yes.
Okay. Explain what happened in that process.
So I was given a few days so I could decompress and rationalize what had just happened. Then I was afforded the opportunity to write a written statement after reviewing body-worn camera and MVR footage of the incident.
And after you completed that review, did you write a statement?
Yes.
And was that statement reviewed by an attorney at the time?
Yes, it was.
And then was that statement then provided to law enforcement once it was completed?
Yes.
Sir, in this episode that you testified to today, do you believe you acted consistent with your training and experience?
Yes, absolutely.
Why is it again you fired your weapon, sir?
I was trying to protect the life of the West Haven officer and Trooper Jackson from the threat of deadly force.
And that's why you acted the way you did.
Yes.
What impression has this left on you?
Objection. Irrelevant.
Sustained. Why was it that you became a police officer?
Objection. Asked and answered.
As I stated before, I became a police officer because I wanted to help people. I wanted to make a difference. I wanted to have a career that had meaning outside of just myself. And there were numerous occasions being a police officer that I was able to accomplish that and put smiles on people's faces.
Do you still want to be a police officer?
Objection, Your Honor. Irrelevant.
Sustain that.
No further questions.
So that would conclude the direct examination, I think. Would you like to just go into the cross-examination, Mr.?
Yes, no. Yes, no, sir. Can we take a short break?
Yes, and but then we can maybe start the cross before lunch. Is that what you were picturing?
Yes.
Okay. All right, so we'll take 15 minutes.
All rise.
did you utilize all those tools
Yes, sir.
along with all the tools of the public records?
Yes, sir.
And does that include birth, death certificates,
Census records.
census records, and things of that nature?
Yes, sir.
Okay. So how did you become involved in this case?
So when I got involved in DNA, I encouraged all my family members to DNA test.
Okay,
And my father-in-law, my husband, my son were DNA matches to the DNA that was found. And so when law enforcement was looking at GEDmatch, my email address kept popping up,
okay.
and that's how I got involved.
So you were actually involved in the family tree that Tina Llewellyn was researching.
Absolutely.
And so because you were related some distant relative or some way in this case, you became involved.
Yes.
And did you do it voluntarily?
Yes.
All right. Did that help in the investigation, looking at the family tree, to be able to know some of the family
Yes, sir.
and to tell them you're part of the family?
Yes.
So what was your part in this investigation as far as looking at the family tree?
So the process that I used was to, since my father-in-law was the highest match that I knew, my job was to figure out how my father-in-law and other DNA matches were connected. Who was the most recent common ancestor on those lines?
Okay, so you started from there.
That's where I started.
All right. And built the family tree from the most recent. Did you start working upward or older or newer?
So you start with the older one.
Okay.
And then you build down.
Okay. So what is it you're looking for as far as trying to match somebody and how closely related they are?
So if I knew that my father-in-law and a particular match were second cousins, that meant they shared like great grandparents. And so I would start from there. And as I build the tree down, I'm looking for connections to other DNA matches to see where they fit in that tree. And I also am looking for information to give law enforcement leads, like maybe an area that a person lived in. If a crime happened in a certain area, you look at that information. If you know if they were male or female, you look at that information when you build a tree, age, things like that.
Okay. Now, sometimes when you start following a tree and you get to the end of that tree, do you discover that you've been tracing the wrong tree?
Yes, sir.
And do you have to back up and start from another angle?
Yes, sir.
And sometimes, and even in this case, do you find out that sometimes there are like a husband that had an affair on a wife and had an illegitimate child that has received a different name?
Yes, sir.
And was that in this case?
Yes, sir.
So it's one trail you had to follow. Is that right?
That is correct.
And do you find that out through talking to relatives and things of that nature?
That is correct.
So when you got to looking at starting off, do you remember how many people y'all had in your tree to start with?
If I remember right, when I gave the lead to Detective Llewellyn, my tree had 7,409 people in it, I believe.
Okay.
Yes, sir.
And do you need, so the way, if you recall, it went like direct examination, cross, then redirect, recross, etc., until whenever it ended. You're all set?
Yes, sir.
Okay, well, I'm going to excuse them.
Yes, Your Honor.
Okay, so you can, do you want to take lunch now? Or do you want to go back for a little while?
Oh, we can take lunch now.
Okay, then we'll take an hour for lunch. We'll come back at 1. And then we'll have an entire afternoon, so, okay. All right, we're in recess for lunch.
All rise.
It's amazing how you disappear when it's time to wash.
I disappear anytime there's work involved.
When I came back from offshore, every day I had a different partner, and then they put me with Ted.
right?
That is
And that when you did, you narrowed it down to basically one individual or two individuals.
2 individuals.
Now, your job is not to say, okay, now we got this, let's match these two together, right? With the,
No, sir.
all you're doing is pointing them in a direction.
Okay.
Did you point them in a direction before, where they talked to some people and it turned out that that was not the person because they didn't have a tie?
Yes,
And did the DNA rule them out?
yes.
Okay. So in this tree, when you came down to two people, what were their last names?
Foreman.
And what was the one that we decided after looking at? Did you decide which one that you would go and test or get the trash or do anything?
No, sir.
All right. All you did was say, here's these two people.
That is correct.
And you waited to see how that turned out.
That is
Now, after they did the search and the testing and everything, did you do any further work on that tree?
After they did the testing, no,
Talking about after they got the DNA results, you did no further testing, did you?
no, sir.
Didn't need to, did you?
No, sir.
Okay, I'll pass with you.
Good morning.
They still only have one motel at Bunkie.
We have 2. I've been staying.
We all might be. I have. We may be Ken from Mansura. But you received, what did you receive to start your investigation from Llewellyn?
I received the names of DNA matches to the person of interest that they were looking for.
Okay. What do you mean by that? The names?
The names that came from the JED match list
Okay.
that was given to law enforcement.
How many names were given, do you know, that you got?
I can't be certain how many.
Rough number?
Rough number 10.
So 10 people that they wanted you to go start searching the family trees.
Correct.
I'm putting it in simple terms,
Okay, yes,
okay? And those 10 individuals, were they separate DNA profiles or do they have to be?
yes, they're actually separate people who match the person of interest from the JED match list.
And were any of those people, those 10 people, did Foreman's name come up?
So once I built, once
No, you're jumping ahead. We're gonna get there.
okay,
But you said you received 10
okay,
10
You
names.
asking me?
Yeah, some 10 names.
okay.
Was Foreman's Foreman name part of the 10?
A surname of Foreman, no, sir.
Okay. But you had DNA?
We had DNA matches to the person of interest, yes. We had the names. Yes, sir.
Okay. You don't know how or where they got those names and matches from?
Yes, sir, those names came from the list that.
Yeah, but I'm talking about how they determined those names and DNA. You don't know anything about the facility that gave them that information off around.
I do know that's where it came from.
Yeah, but you don't know how they did it or
No,
whatever.
sir.
That wasn't, and that's my point.
Okay,
You weren't involved in that.
no, sir, I was
Okay.
not involved.
And after you pointed them to two individuals, do you know what they did with the other 10 people that they gave you to research? Did you give them any direction or did you?
So can I explain a little bit about what I did with those, say, 10 names?
Okay,
Is I figured out how or if they matched my father-in-law to find the most recent common ancestor to build the family tree. And that's all that's done with those names.
right. And I guess my question is that after that, you didn't do anything with the other DNA that they had, or names that, through DNA that they gave you?
No, sir.
Okay. After you gave him the two names, you didn't do anything else with this case? You didn't have any other involvement with this case after you gave them, you did your work?
I did my work.
Okay. And when did you finish that? About 2001?
Yes, sir. That was in April of 2000.
Do you know when in April? Rough date, was it the end of April, beginning of April? Beginning of April? Thank you very much. Pass the witness, Joe.
First thing, was it 2001 or 2021?
2020.
Okay, yeah. That's okay. I just want to make sure it's clear for the record. And also, you mentioned the word and you keep saying the word match.
Yes.
Okay, those are not, we're not matching people, are we? You're actually getting relationships.
Correct.
Okay, and so it's kind of like my kids used to play a game where they'd hide something and you know, say cold, you get warmer, you get hot. And that's pretty much what you're doing with the DNA, with the DNA and the talking the family tree is you start following it until you get warmer and warmer and warmer. And then you got a direction to point. Is that correct?
That is.
Okay, I'll pass it.
May this lady be excused.
Please,
You're
Judge.
excused. Thank you, ma'am. Next, please.
Judge, can we approach?
Yeah.
With all respect,
you recall, reading that statement and what you said was that do you recall telling police that, when they asked you what did you touch, that you said up here or on top, of my breast really strong?
No,
You don't recall giving that statement?
no.
You don't recall?
asked and answered, Judge. How many times you gonna answer the same question? She said, no, he hasn't answered. He answered it twice.
Thanks, Judge. Okay. No more questions, Judge.
No questions.
All right, thank you. You may start.
Okay, Mr. Williams?
If I could have just one here.
Save you some time, Mr. Williams. As it relates to count one, criminal sexual conduct, second degree, the missing element that you have here is sexual contact. It is clearly indicated, although there was sexual contact, meaning contact, it was not, okay, nor can it be construed as being sexual contact. However, it was an offensive touching. So what we have here is an assault and battery, as opposed to criminal sexual conduct in the second degree.
Well, in your honor, I was going to move, based on the testimony, I would amend the information to, I would move to amend the information to add a count of costing minor. The evidence we have here is that this is a individual under 16. For costing with the intent to commit an act or submit to sexual intercourse or an act of gross indecency, or encourage a child under the age of 16 to commit these described acts. I believe that the evidence based on
What's the statute?
that's going to be 750-1458. That is 750.145A, and that is a result.
All right, Mr. Upshaw.
I'm trying to read that scripture, but I reject. First of all, I just put it up. Thank you. First of all, Judge, when you get ready to amend and add an entire new charge, you can't do it at the end. The one thing about the judicial system is that we're supposed to have fair play and notice. No notice was given this. We prepared based upon what the prosecutor accuses. Now, after the court hearing and everything is out, he attempts to add an entirely new charge. It's not a lesser of the two, it's an entirely new charge, and that's inappropriate. I have no notice, I didn't prepare for that. And I know he didn't intentionally because he's always a good guy, but I'm not saying, someone else would say, I would be sandbagged. I have to have notice, I was given no notice, and to this. And furthermore, there's not only there's a lack of notice, I think the question was, what did you do? Not would you do? What's the nastiest thing you ever done? Not do some nasty act to me. Now we can assume whatever facts we want, but he did not ask her for sex. He did not try to prostitute her. And normally these are the things, what happens when you attempt being nosy and being wrong and asking questions. It's not even what this statute is about. It's enticing a person to do an act.
And he tells us what his intent was, right? He was trying to shoot a shot.
That and shoot the shot leads to interpretation, and I understand it can be interpreted in many different ways, but Judge, it's still the fairness. The fairness that if that was the prosecutor's intent, it had to be alleged prior to the preliminary exam being conducted, not after.
I'm sure Mr. Boomers didn't know that either until the facts came out, how the testimony came out.
And even then, he didn't put the court on notice to after he rested and I made my closing argument. And that's inappropriate. If he was, once
So
he
to
heard,
remedy this situation, would you like to recall the witness and ask what additional questions
Judge,
as it relates to this particular charge?
I would like to, even on these records, Your Honor, I would still hold tight that there's no enticement here. Based on the four corners of what we heard, there's no enticement. Now, we may consider a person wrong for answering those questions. The prosecutor didn't.
What about the touching game? That was enticing.
Did you ever play the touching game?
You want to play the touching game? That was the question.
I think as the record stands, Your Honor, there's insufficient evidence.
All right, the court, after hearing the testimony of Samantha Hutchins, and although the prosecution has made a last ditch effort to get this matter bound over, the statute that they've given the court, 750.145A, fits squarely into the facts as were testified to by Ms. Hutchins. That statute reads, a person who accosts, entices, or solicits a child less than 16 years of age, regardless of whether the person knows the individual is a child or knows the actual age of the child, or an individual who he or she believes is a child less than 16 years of age, with the intent to induce or force that child or individual to commit an immoral act, to submit to an act of sexual intercourse, or an act of gross indecency, or to any other act of depravity or delinquency, or who encourages a child less than 16 years of age, regardless of whether the person knows the individual is a child, or knows the actual age of the child, or an individual who he or she believes is a child less than 16 years of age to engage in any of those acts is guilty of a felony punishable by imprisonment for not more than 4 years or a fine of not more than $4,000 or both. Again, the allegations that this court heard from Ms. Hutchins fit squarely within that statute, in that the defendant allegedly asked the complainant to engage him in the touching game, asked her, and he made admissions to the police about her allegedly jacking someone off, and he wanted to find out more about that, and he wanted to shoot his shot. Court is satisfied that people met their burden of the amended count 1 of accosting, enticing, or soliciting a child for an immoral purpose, as well as the added count 2, assault or assault and battery. The court finding those charges were committed in the city of Detroit. The court finding probable cause for these commitment will bind the defendant over to Wayne County Third Circuit Court Criminal Division's further proceedings. His arraignment on the information date and time will be March 29th, 2024 at 9 o'clock a.m.
Thank you very much, Your Honor.
Thank you.
Yes. Yes, to put a bill. Yes.
Oh, that's what you can say.
Yeah.
Should be of any sort.
Okay, who is this?
Ms. Fountain.
Townsend. Calling case 2455765, people of the state of Michigan versus Anjanaria Virginia Townsend. Defendants charged in count 1, child abuse, second degree. Count 2, child abuse, second degree. Count 3, child abuse, second degree. Count 4, child abuse, second degree. Count 5, reckless driving. Appearances for the record.
Good morning, or good afternoon, Your Honor. Brittany Johnson on behalf of people, P83513.
Sydney Henderson with India's P84839, appearing on behalf of Ms. Townsend. Ms. Townsend, please state your name for the record.
Ashmaria Thomas.
There's a date and time set for preliminary examination. Are you ready to proceed?
Your Honor, the people are unable to proceed. Necessary witnesses not being present. We contacted the families yesterday. They informed us that they would be here today. They have not been, I have not seen them out in the hallway. It's now 12:37. This was scheduled for 12:15.
Your Honor, given that information of Ms. Townsend's statutory right to hold preliminary exam and 5 to 7 days after the proper class conference, dismissal of this matter.
So order, court will dismiss this matter without prejudice.
Thank you, Judge. Thank you.
There you go.
I need to dismiss what you did.
Would you like to just go into the cross-examination? Mr.
Yes, no. Yes, no, sir. Can we take a short break?
Yes, and then, but then we can maybe start the cross before lunch. Is that what you were picturing?
Yes.
Okay. All right, so we'll take 15 minutes.
All rise.
Ms. Efron conducting the cross-examination of this witness. All right, and Ms. Efron, do you have any objections to continuing without Ms. Conley's presence for the questioning of this witness?
No, no.
And Mr. Ruiz, do you have any objection to continuing with this witness without the presence of Ms. Conley? All right, let's bring the jurors in, if you'll let her know, please. We're ready.
All right, with the jury.
All right, everyone, please be seated. So where we ended is state you had passed the witness, is that correct?
Yes, Your Honor.
All right, defense.
Thank you, Your Honor. You know, Ms. Conley's not here and I'm proceeding without her, right? So with regard to this examination, you can describe to the jury what you saw, correct?
Correct, what is documented in the examination.
Right, what you saw and what was documented. But you cannot tell this jury who caused a particular bruise, correct?
Correct.
And you cannot tell this jury who caused a particular injury, correct?
Correct.
And I'm gonna call it rhabdo. I could never pronounce that whole word. That is a progressive, it can be a progressive condition, correct?
Correct. It actually develops, again, you have your muscle injury, then those chemicals are released and you develop renal failure. So it's a full progression of rhabdomyolysis.
And it might not happen. Does it happen does that process begin at the time anybody has a severe muscle injury?
Well, the process begins when you have the muscle injury. But then again, whether or not you develop into renal failure, that depends on how much of a muscle injury you have, the ability of your body to clear it. But normally the whole rhabdomyolysis syndrome, so we're talking about the injury.
No, yeah, objective, non-responsive.
All right, that will be sustained.
Thank you, doctor. The rhabdo is, you wouldn't be able to give any kind of particular time frame as to how it develops, correct?
So as I was getting to, it usually takes 2 to 3 days to develop.
Okay. But one injury can add to a prior injury, correct?
Correct.
Okay. And with regard to who caused the death of Mercedes, you cannot say, can you?
Correct.
Now, this you can say is a homicide, correct?
Correct. It was determined to be a homicide.
But that's not a murder, is it?
Correct.
You cannot tell this jury that the crime of murder has been committed, can you?
Correct, I cannot.
That's for them to decide. You agree with that, correct?
Correct.
Okay, so can you illustrate or describe to us what the homicide is and what the other categories that you make in an autopsy?
So again, we're referring to manner of death and manner of death on a death certificate. These are epidemiologic terms. These are so people who study how and why we die and generate those graphs that you've probably seen why people are dying, right? It's so that public health can see why we're dying. For instance, you've probably seen things about the suicides going up. That's from death certificate data based on these manner of death determinations. So natural deaths being deaths due purely to natural disease processes. accidental deaths being due to acts of nature, like hurricanes, tornadoes, floodings, or events with no intention for injury. So, for instance, car accidents, right? Suicides being a death where someone has caused injury to themselves. Homicides being where someone has caused injury to another. And undetermined being we don't have enough information to decide between the manners of death.
And so those are when you determine manner of death, those are the 5 categories that I guess, is it the state of Texas has established for you? Is,
Correct. Those are the manners of death that appear on the death certificate as defined by state law.
and you've never met Jose, correct?
Not that I know of, no.
And you've never met Katrina, the
Not-
co-defendant in this case.
Not that I know of, no.
And you were obviously not present when any injury occurred, correct? And it's a lot of information, but the information you're communicating is solely as a result of what you saw and what you reviewed for today, correct?
Correct. It's part of our investigation into the death.
And did you review things before you testified today?
Yes,
Your autopsy and notes and those kinds of things?
correct. The entire file, which would be the autopsy report, the investigative report, the photographs, the radiographs or x-rays, the microscopy that we discussed, the slides under the microscope, all of that was reviewed.
Okay. And when you say a particular injury was the result of trauma, you can't say what particular kind of trauma it was, can you?
Other than blunt force trauma.
Other than blunt force.
Correct.
But blunt force trauma, would you agree, can occur in many ways? It's not necessarily from a physical act. It can happen if you forcefully bump into, crash blunt force trauma can happen in many ways.
Correct. It can happen in an infinite number of manners.
So it doesn't necessarily mean that it came from, say, a strike or a blow by another individual.
Correct.
I pass a witness at this time.
State.
Dr. Molina, was there anything in Mercedes' medical history that suggested that these injuries were all because of an accident?
No.
Was there anything in Mercedes' medical history that suggested that these were self-inflicted injuries?
No.
Your Honor, may I approach?
Yes.
I'm going to show you what's been admitted in State's Exhibit number 97.
In defense, if you need to move about to see what's being shown, you may do so.
This is a photo that has been identified as a photo of Mercedes that was taken with Jose Ruiz's phone. In fact, by Jose Ruiz. And there has been evidence that this picture was taken at 4:44 p.m. And then there's additionally video evidence from basically from 6:30.
Your Honor, object to the testimony from counsel.
Sustained.
If a child is forced, this is Mercedes. Mercedes holding an item like this with her arms out like this from 4:45 p.m. till roughly 7 p.m. Would that be something that you would feel would contribute to the rhabdo?
Yes, that could certainly cause rhabdomyolysis.
How's the witness?
Any further questions, defense?
And again, that's because the rhabdo can be caused by contact injury or or exertion, correct?
Correct. In this particular case, I'm being asked would be exertional. Yes.
Okay. And again, you're not here to make any legal conclusion, correct?
Correct.
I pass witness at this time.
No further questions.
All right, is this witness excused or subject for recall?
Excused.
I guess it's just subject to recall at this time.
All right. All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone. You can't view anything. The only persons you're allowed to speak to are attorneys for the state of the defense. Thank you. You may step down.
Yeah, no.
And we're off the record. Ladies and gentlemen, what's going to end up happening now is we're going to recess for today. I'm going to have you all come back on Monday at 9 a.m. This is the thing about the Mondays. You have all jurors brought up on Monday. So the same amount of jurors that you saw when you first came, that's going to be the same amount. So in order to make sure that you have a parking space, you probably need to be here by 8:30. The jury room will be open. Deputy Laura will let you know where you need to be. Remember my instructions. You're not allowed to start to deliberating internally with yourself, with each other. You're not allowed to discuss any testimony that you've heard with anyone. You're not allowed to view anything. Everything that you need to know about this case is to come from inside the courtroom. Does everyone understand? And if there's anyone who needs another letter, just let the deputy know. We'll make sure you have that. But it is close to 12. Even though it's cloudy outside, like London weather, you still have a free day to look at the Riverwalk. People don't go to the Riverwalk that much when they're here. I always wonder, do they realize how beautiful it is? So just look at it from a tourist point of view. All right. All right, everyone, please rise for the jurors. Don't shut down your record, just. All right, everyone, please be seated. All right, so what's going to end up happening is state and defense, you all are going to confer, and then we'll see where we are.
Yes, Judge, we will. I was gonna say she's not here, but yes, we will confer.